A subpoena? Ellie, I got a subpoena. Should I give them the client's records? No. What do you... I know what I'll do. Should I give this person my client's records? Outlook not so good. Hey YouTube, Ray coming back at you again with another video, this time on subpoenas versus court-ordered. Okay, let's begin. A subpoena is a written request to provide records, or it can be a request to appear in court. Who typically sends subpoenas? Lawyers, judges, or it can even come from the court. And that brings us into what exactly is asserting privilege. Okay, asserting privilege is essentially our superpower as the social worker to deny requests if the client does not want us to share their records. I don't know that person. Huh? Excuse me? Now, as great as that is, being able to assert privilege, unfortunately, we do have limitations. When the subpoena is coming from a court, we're out of luck. When the subpoena is coming from a judge, also out of luck. We can't assert our privilege. Lastly, when the social worker is subpoenaed themselves to do an appearance in court, out of luck. No superpower for us. Now, hold on. I know. There are times still where we can assert our privilege or our superpower. One example of this is when we receive a subpoena request coming from a lawyer. With that being said, let's jump into a scenario, how it will be phrased in a question form on the exam. A social worker is subpoenaed by a lawyer for the written records of a client. What should the social worker do first/next? Whether it's first or next, let's kind of walk through. And remember, keep the serial method in mind. So in this scenario, the social worker, you received the request for a client's written records coming from a lawyer. So right off the bat, the first thing we will want to do is contact the client and keep them in the loop of what exactly is going on. We want to call them on the phone. Hey, this is going on. We received a request from so-and-so. How do you feel about that? Should we provide them with the records or not? Because the client could say, sure, yeah, that's perfectly fine. Give the lawyer our records. Yeah, no problem with that. Or the client could say, no. I don't want that lawyer having my personal information. And then in that sequence, we will assert our privilege or our superpower. And just to be clear, before we do anything with the subpoena, we want to contact the client first and keep them in a loop and inform them of what's going on exactly. And if that's one of the answer choices of what you do first or next in that given scenario, if we have the answer choice, contacting the client first to kind of update them about the situation, that would be the correct answer. I know in the scenario it said the request was coming from a lawyer, but even still, if it was coming from a judge or a court, we would still want to contact our client first before turning over anything. Again, our best interest is for the client. We want to keep them in the loop, and we'll touch on if it's coming from a judge or a court, or if it's court ordered in a second. But again, we want to keep the client in the loop. So if that answer choice is available, that would be the correct answer for the given scenario. I know you guys may be thinking, okay, Ray, okay, how about if same scenario, but it is coming from a judge. The judge is requesting the client's records. What do we do then? Again, we still contact the client first if that answer choice is available. However, the exam can be tricky, and this is what really trips a lot of people up. Keep the serial method in mind, and we're going to kind of walk through that now. For those that are unfamiliar with the serial method, it's a method I came up with to kind of break down how to navigate through these first, next, best type of questions. And with the serial method, think about literally when you're preparing a bowl of cereal. First comes the bowl, then comes the cereal, then comes the milk, and then comes the spoon. So when we're dealing with the scenario, let's see how we'll apply that method to the scenario itself. Okay, so we're going through, and contacting the client isn't one of the options. Or let's say if it was already in the question stem of after the social worker has contacted the client, what should the social worker do next? The first option of getting the bowl is already done, whether it was said in the question stem or it's just simply not one of the answer choices. So we have the bowl. Next, we move on to the serial. What's the serial next in this given scenario? As a social worker, remember, you have the client's best interests at heart. So if a judge contacts us via the subpoena, we want to advocate for the client on their behalf by expressing the need for confidentiality or a limited release of their information and not give up all of their records. We do that by explaining to the judge, like, hey, like, I know you requested all of the client's records, but there's a lot of personal information within those records that could have nothing to do with the reason why the judge is requesting all of the client's records. So we really try to advocate for the client to have possibly even a limited release of the information being requested if, let's say, the judge said, I want all of the client's records. You know, our client, or anyone for that matter, doesn't want that stuff shared with, outside that therapeutic room. So we just really want to advocate for the client on their behalf. So the correct answer in that scenario would be some form of advocating on behalf of the client, communicating the judge to say, hey, is it possible to have a limited release of the client's records if the bowl was already done of contacting the client, whether it was addressed already within the question stem, or it's just simply not one of the answer choices. We would go next to the serial, advocate on the client's behalf. That would be the correct answer choice. So since the bowl or contacting the client is either already addressed in the question stem or it's just simply not one of the answer choices, the thing that we will want to do first or next is advocate on the client's behalf of a limited release of the information, or any at all, seeing if the judge actually needs it or if the judge can go without it. Don't forget to like, comment, and subscribe, as I plan to come out with more content and dive further into how to exactly address these difficult dilemmas that social workers may find themselves in. So with that being said, see you soon.